Hi, this is Greg Maxwell with Amicus Law Firm. We do estate planning for individuals and families here in the state of Utah. And one question we get is, why do I need an estate plan? What happens if I die without a will or without an estate plan? And it's a good question. What happens if somebody dies without a will? So if you die without a will in the state of Utah, then essentially the laws of intestacy take over. And so the state of Utah has various statutes on the book, generally in the probate code, that outline what happens to a person's belongings, and what happens if they have minor children, and whatever the case might be, if they pass away and they don't have a will. So the laws of intestacy take over. So somebody, whether it's a relative, it could be a creditor, it could be an interested party, will start the probate process and get the ball rolling in the probate court. And then the probate court will allow time for creditors to make claims on properties. If you have debts, that creditors can then make a claim on your property. It sorts through where your children will go and who will raise those children. If you died with minor children, it lays out which generations of heirs will receive assets and when. And so the state essentially is trying to do your estate planning after the fact for you. So it's obviously better to avoid that intestacy process and do it yourself, so that you are the one that is deciding what happens to your children after you pass away, who's going to raise them, what funds are going to be used to raise them, where your stuff goes after you pass away. All of those things are reasons to do estate planning and to not die intestate, or to not die without a will. So regardless of whether you're single, whether you're married, whether you have lots of assets, whether you have very few assets, whether you have children or not, creating an estate plan is always a good idea. And it's not only important for what happens after you pass away, but half of estate planning has to do with what happens while you're still alive, in the event that you become incapacitated. We'll talk about medical directives and powers of attorney and things that still affect you while you're still alive, but may be incapacitated for whatever reason. So just do yourself a favor, do your heirs a favor, and create an estate plan for yourself. It doesn't have to be hard. It's not hard. It's a very simple process, and we'd love to help walk you through that process. So give us a call and we'll chat with you about it.